Hi, I'm Sina Mohajer from Mohajer Law Firm. We specialize in family law, estate planning, criminal defense, and personal injury. You probably noticed that we are currently indoors and not strolling in a beautiful park. Well, regardless of rain or shine, I want to take these opportunities to provide you with information that can potentially help you in your case. Although we are not walking in a park, the information you receive is meant to be simplified as if it is a walk in the park. So if you like the contents of this video, please hit that like button and don't forget to subscribe so you're always informed of any new videos being posted. And without further ado, I welcome you to our series called A Walk in the Park. Now, I want you to think about this question. What do you think happens to your money, home, and personal belongings if you die without a will in California, especially under the updated 2025 laws? Now, although the state has a default process, it may not accurately reflect your actual wishes, and it can lead to confusion, conflict, and even court delays. So in this video, I want to address what happens if you die without a will in California, especially in 2025. Specifically, I want to go over what is intestate succession, who gets what under California's 2025 intestacy rules, the risks of dying without a will, and lastly, how to protect your family and legacy with a proper will. So let's just jump right in. What is intestate succession? When someone dies without a will, they are said to have died intestate. In California, their estate is distributed according to intestate succession laws, which is a fixed legal formula that decides who inherits what based on family relationships. Now, these laws prioritize spouses, children, parents, and siblings in that particular order, but they leave no room for personal preferences, charitable gifts, or even friends. Even if you live with a partner or have stepchildren, they may receive nothing if you die intestate, unless legally adopted or married. So who gets what under California's 2025 intestacy rules? If you're married with children, your spouse may receive half or more of the community property and a portion of your separate property, but your children will also have a legal share. If there are no children, your surviving spouse may share your estate with your parents or siblings, depending on the family structure. Now, if you die single with no children, the estate may go to your parents, siblings, and nieces and nephews, or eventually to distant relatives you may not have intended, and it will most likely be in that same exact order. Now, as of 2025, legislation has streamlined probate timelines and slightly altered the share percentages in certain blended family scenarios, but still offers no discretion for personal intent. So what risks exist of dying without a will? There could be significant probate delays. Without a will, the court must appoint an administrator, verify the heirs, and oversee the distribution of assets, a process that can take months or even years. There could be family disputes. Disputes over who should inherit what are common in intestate cases, especially when no written wishes exist to guide decisions. There could also be unintended outcomes for the person who died. Valuable assets may end up in the hands of estranged family members, while lifelong friends or unmarried partners or favored charities are completely excluded. So even a simple will can prevent most of these issues and give you control over who receives your assets, who handles your assets, and how quickly your wishes are carried out. So how can a will protect your family and legacy? I'm going to try to make this super simple by outlining the key steps to take. 1, you draft a valid California will that clearly names beneficiaries and an executor. Consider adding a trust to avoid probate and maintain privacy. You'll want to update your documents regularly, especially after major life changes. Include backup choices for guardianship, executors, and beneficiaries. And lastly, always a good idea to consult with an attorney to ensure your estate plan complies with California law and the 2025 updates. Please do not rely on do-it-yourself templates. A small, simple mistake in wording or signing can invalidate a will. I have seen this way too many times, and it's too late for you to do anything about it as you are not able to speak up. So a custom plan ensures clarity, legality, and peace of mind. So to recap, if you die without a will in California, the state decides who gets your assets, and their choice might not match your wishes. Probate delays, family dispute, and unintended heirs may receive your assets that you did not intend for. A clear, legally valid estate plan puts you back into control and protects the people you love. So if you've got questions regarding your case and would like to speak to a seasoned estate planning attorney, I welcome you to contact our office and schedule a consultation. We would be more than happy to sit down with you one-on-one and to discuss your options. And as I stated in the beginning, if you like the contents of this video and you found them to be helpful, well, hit that like button and don't forget to subscribe either so you're always informed of any new videos being posted.